Matter of Bentkowski versus City of New York. Counsel.
May it please the court, I'm Richard Deering for the City of New York. Your Honor, I'd like to request 4 minutes for rebuttal.
Yes.
The judgment in this case rests solely on a theory of promissory estoppel that is remarkable in a number of ways. First, that it overrides the results of a robust collective bargaining system. The plaintiffs here concede that the benefits they seek, or the particular regulatory treatment they seek to be guaranteed for life, was not obtained by their collective bargaining representatives in negotiations while they were active employees. That is conceded. Therefore, they're trying to override the outcome of those collective bargaining sessions. They're trying to do so for a group of some 250,000 employees of the City of New York. They're trying to do so to obtain a lifetime guarantee, which are remarkable and rare in themselves, but a lifetime guarantee not of health coverage, but of a particular regulatory treatment for their health coverage. And they're seeking to do it based on a record that is deeply inadequate.
And what do you say with respect to the things that they rely upon as establishing the promise that they claim exists?
I think they don't withstand any scrutiny. If you take a look at them, and I'd like to start, if I could,
The SPDs?
with the SPDs, which I think are really the linchpin of this case. And if they're not right about those SPDs, establishing a clear and unambiguous promise.
So what are the SPDs?
Right, then the whole case fails. The SPDs are fundamentally a descriptive document, not a promise-making document. It's in the title of the document, Summary Program Description. What they do, and the plaintiffs in the last case pleaded that this is what the SPDs do. They describe the health benefits available for that year. They're issued year over year. They're always subject to, sometimes more frequently than once a year, they're always subject to being superseded by the next SPD, which states a different state of affairs. So they are a description of the current program. They are not a promise into the future.
Is there any relevance to the fact that they change?
There's tremendous relevance to the fact they change frequently. In fact, SPDs are reissued again and again and again because they change. And the plaintiffs agree that basically everything else, or almost everything else in the SPDs, was subject to change and has changed. But this one passage that honestly is quite unremarkable in context and is the one thing that was an immutable lifetime promise. It doesn't say it's a lifetime.
Is there any language that says this is subject to change, or that this is just a description which could change, or anything to that?
Of the I mean, there is language that says the title is description. The first page of the document says this is information about the benefits program. It's not an agreement, it's not a contract, it's not a promise. And there is language that says that the benefits are determined via collective bargaining, they're subject to budgetary constraints, there have been, so there is a lot of language early in the document that says those things. I think the most significant thing is that the document by its nature, and I think this point is conceded, is not a promise-making document.
So could it be?
Could.
And so if the language was unequivocal, could the city be bound by an unequivocal promise to continue the coverage forever?
I think it possibly could. I think and I'll give you an example.
Outside of the collective bargaining agreement.
I think there's an argument to be made that it is entirely ousted by the field of collective bargaining. I think that's the Second Department has reached in a number of cases said, look, if you have a contract, you can't come back and claim additional things via promissory estoppel. So I think there's an argument to be made here. At a minimum, it needs to not just be clear, ambiguous. I don't know if this concept exists, but really clear.
So what would the standard be, setting aside the question of whether you could have a promise outside of a collective bargaining agreement? What's the standard for thinking about promissory estoppel in the context of a government entity, would you say? Is it any different than it is between two private parties?
I think it is. This court's decisions have recognized over many years that it requires an even higher showing. It's rarest of cases, manifest injustice against government. I think the collective bargaining point is frankly more significant, but I'm sorry, Your Honor.
No, could you ever have a government entity promise to do something forever and then bind every successive legislature or administration or something like that?
I think you've tapped into, there is a line of cases, we cite one from this court in our brief that says at a minimum, it would require the very highest showing to find a conclusion that the government has fettered its power into the future in that way. And so I think you could rule that it can't be done. I don't think you need to go that far in this case to resolve it.
And what about if agents of the government sort of promise that? So like this, the affirmation from the deputy mayor.
The affirmation of the deputy mayor, I think it's worth talking about what kind of language you might see in an SPD that looks more promise-like. But the affirmation of the deputy mayor is fundamentally rooted in the SPD. If she's wrong in her understanding of the SPD, which I submit she pretty clearly is, then everything in there about promise is basically out.
Well, how can it, I'm sorry, how can it be? She's the deputy mayor for Health and Human Services, commissioner of the Department for the Aging, and head of the Departments of Employment, Personnel, Health, HPD. I mean, she's saying, it says here, she states unequivocally for more than 50 years this was the promise. I mean, if she was that wrong, one would think such a high-level representative would be corrected, given the stakes.
Well, she relies on the SPD, and I think the SPD is in the record.
She heads the whole program.
She doesn't, honestly. She never said she headed the whole program.
She
held a number of high-ranking positions. She doesn't say she ever had anything to do with the employee benefit program in the city of New York. She doesn't say she had anything to do with SPD creation, drafting.
She's not the head of the Departments of Employment, Personnel?
That's a position she has.
One would
benefits
think
are
they
run by
would know
Office of
whether,
Labor
excuse me,
Relations.
one would think that such a high-level person would understand whether or not there was this kind of promise, considering that it becomes, according to some of the evidence, a basis for recruitment. People made life choices, supposedly, based on what you now argue is a non-promise.
The SPD speaks for itself. Even high-ranking officials can be wrong. The SPD speaks for itself, and it does not include the promise.
For 5 decades?
The SPD, I agree with you that the sentence, this one sentence of the SPD was in a lot of SPDs over a number of years, but it doesn't make it a promise. It doesn't change its content. And if you look at the statement, it's a description of the way the program was.
So the SPDs trump individuals who are speaking for the government?
She never says if you read that affidavit, I think this is really important. She never says she spoke to anyone and made a promise to anybody. In fact, she writes this is a really important point. On page 2597 of the record, you can see paragraph 28 of her affidavit. She writes that in a very buttoned up and limited way. She does not say she ever promised anything to anybody. What she says is, I had a lot of conversations.
Hypothetically, then, could an individual that is an agent of the government trump the SPD?
I don't think so. I mean, the plaintiff said in their pleading that the SPD was the authoritative source of information about health care benefits in the city of New York. I do just want to give it.
Well, before you go further, so what do you take? I'm quoting from the AD, but it's right from her affidavit, that the city agency, I'm quoting, city agency HR people, as she should know, since she's heading up HR, reiterated this promise of choice to generations of prospective city employees, the guarantee of good health care and retirement, including the choice to participate in traditional Medicare with a city-paid supplemental plan, was an essential recruiting and retention tool. Again, how would someone placed so high level for so many years be so wrong and is never corrected?
Well, I want to make 2 points.
Yes.
The first one is the same point that it is, if you read the affidavit, her point about promise is rooted in the SPD. The SPD speaks for itself. It's in the record. You could read the passage, read it in context, and you will see that it is incorrect, that it is a clear and unambiguous promise, certainly not a clear and unambiguous promise of any lifetime benefit. I'll also say to you, even as she frames the promise, she does not say it's a lifetime benefit. She stops short of that. She says they were promised that when they retired, they would have a choice. That's true for the retirees. When they retired, they had a SUP available. She didn't ever say it was a lifetime guarantee, and no language in the SPD says it is. To talk about the issue of whether she would be corrected, clearly, as any attorney would, I would prefer that there would be a direct rebuttal of that affidavit. The bottom line remains, however, that the affidavit is deeply insufficient to get them over the finish line. And I just want to talk, if I could, for a minute about the choice that was made.
Do you do you agree that regardless of what you think about whether or not this is the exact promise, do you agree that a promise of access to city-funded healthcare in retirement could be used as a as a recruitment tool?
I don't disagree that it could be used.
Was it used as a recruitment tool?
I have no
Or
basis to
was
say that one way or the other.
I'm sorry, what?
I have no basis to say that one way or the other, but what
does
we
the
do
record
know is
show?
they're still
What does the
getting.
record show?
What?
I'm talking about the record before us.
I
Anything
grant
to
you that
suggest it
Deputy
was used as a
Mayor,
recruit-
the Deputy Mayor's
tool.
affidavit says that it was. I have no basis to say whether it was one way or the other. I do want to hasten to add, though, that this is important, they're getting health care paid for by the city. We're reimbursing their Part B premium. If you look in the record, the chart at 4057 to 4061, side-by-side chart of the two plans, the plans are mirror images of one
Can I
another. So
ask-
it's not, yes, Your Honor.
Go ahead.
It's not right to say they're not getting health care. What they're saying is they're claiming is a particular regulatory treatment for the health care.
Can I ask you to explore a little bit your view on when a government employee can bind the government itself? I mean, there are probably differences. Are you a high-ranking official? Are you speaking about something that's within your programmatic authority? Or are you not? What's your position on that? In the absence, let's say, of some written document that memorializes some understanding.
Yeah, I frankly don't see evidence that can happen going forward into the future in this way, particularly when there's a formalized collective bargaining process.
Yeah, but I just mean as a matter of law, right? If someone is recruiting, for example, maybe set aside the CBA wrinkle for a second. If someone is recruiting but not a senior official and makes some promise, for example, not with respect to insurance coverage, but I promise you a 50% salary increase next year. What's your take on the scope of authority to bind?
I think if it's a low-level official, they don't have the scope of authority to bind. There are processes in the city of New York for reaching contracts. They are highly technical.
Is that a function of kind of common law authority, apparent authority, or are there different rules with respect to the government?
I think there's probably at this point a range of statutory rules that describe the authority. I do want to draw one distinction, if I could briefly, because I think this is important. There is a difference between equitable estoppel. A number of the cases that the plaintiffs rely on are equitable estoppel cases, and promissory estoppel, which has this distinctive character of binding the government into the future. Here it's to bind the government for a lifetime promise to 250,000 retirees.
If I could, I want to explore Judge Halligan's question a little more deeply, because I think there are affidavits in the record from city employees who talk about meeting with benefits people who made allegedly certain promises to them about what would be available to them at retirement, maybe how long it would last for. And they're not high-ranking city, I wouldn't consider a benefits person a terribly high-ranking city official, but that seems to be, at least in part, what the court was relying on. Does that meet the legal minimum for promissory estoppel? Or if not, what would it be, to go back to the last question?
I think not, that it doesn't, that a low-level official is not in a position to do that. I also think if you examine the evidence about what they purportedly promised, the evidence is lacking even on its own terms. If I could, I wanted to give an example from a case called Devlin of an SPD that was found to at least present, not in a case where the clear and unambiguous standard applied, to at least present a factual question on whether there was a lifetime promise, and just read you that language as a contrast with the language we have here. That case said it was about life insurance benefits, and the SPD said we'll provide the life insurance benefit, and there's a quote, for the rest of your life at no cost to you. Another document by the same company said that you will be insured for the remainder of their lives. That's what the SPD said. You won't find any statement equivalent to that or even
I
close to
still want
that
to go back
in
to the
SPD here.
collective bargaining question. So in the circumstance, for example, that Judge Canataro just meant, prospective employee goes to somebody affiliated with the city and strikes a bargain that is different from what is in the collective bargaining agreement. can a represented employee strike a bargain?
There's something called direct dealing, which is prohibited, which is to have a bargain struck outside the collective bargaining process, not through the official union representative and official channels. And so I think at a minimum, that question would be a difficult one, if not prohibited. I don't think we have anything factually or on the record that approaches that level, but I do think it raises a difficult question at a minimum.
Is there anything in the CBAs themselves that notifies plaintiffs or employees that their health insurance benefits are covered by the CBA?
In the CBA or in the SPD?
No, is there anything does the CBA itself expressly address health insurance coverage? And
CBAs do have provisions about
is
health
that
insurance coverage.
in the record?
I don't know
or
if it's
no?
in the record here because there's not a claim made under the CBA. In this case, they formerly made that claim and now have abandoned it.
You were about to answer, or you were about to make a statement earlier, and there was a question that stopped you, but I was wondering, it sounded to me as if you were going to go into the record that we have in front of us, why it looks the way it looks.
I was, yeah, and I
Could you
appreciate
just
the
address
opportunity to
that
do
for a
that
second?
because there's a few points to unpack there, right? One is there's two sides to this equation, right? We both agreed that the court could move to a final judgment on the record that had been created. The plaintiffs locked themselves in as a result of that to the record they have, which we think has serious problems. And as a result, we didn't put in additional factual information that would have maybe rebutted aspects of the point by point of the deputy mayor's affidavit, even though we don't think that affidavit gets them close to the finish line legally. And I'll talk to you a little bit about our process. And as I said, as any advocate would.
Can I just cut to,
Yeah.
Was it a strategic decision, or was it a time
I can tell
decision?
you we were already sitting on a preliminary injunction, right? The court had entered a preliminary injunction. What we knew is we had no likely path to this court's review without a final judgment. And we also knew that if we went down the road of factual development, discovery, et cetera, et cetera, et cetera, et cetera, we might still be in Supreme Court right now rather than in the Court of Appeals. So I grant you that we forewent certain opportunities, and as an advocate, you always would rather, even points you don't necessarily think are relevant or decisive, have them rebutted point by point. I would rather be here in that situation if all other things were equal, but all other things were not equal. We were sitting on a preliminary injunction. We had no path to get to this court at that time, and if we went down the road, at that point they had 12 causes of action. Now they have 3. They jettisoned 9 of them in the course of this process. If we went down the road of factual development, full discovery, motion practice, et cetera, on a 12 cause of action complaint, we probably would still be before Justice Frank right now today with a preliminary injunction rather than here in this court trying to get this issue resolved.
Thank you.
Good afternoon, Your Honors, and may it please the Court. Jake Gardner from Walden Mock, Herron, and Williams on behalf of the respondents. Promissory estoppel is designed to prevent the very type of injustice that is present here. The elderly and disabled retirees in this case worked.
So what are the sources of the promise?
The sources
Is
are...
it correct that it's really only the SPDs?
Not at all. As the First Department found, the promise was made not just in writing in the SPDs, it was made in person, orally, by the highest levels of city government, and pursuant to that policy, that essential recruiting and retention tool, it was communicated.
You mean the SPD specifically or something else?
The in-person promises made.
And is there
through-
any evidence in the record that those individuals that the affiants describe had authority to enter into a binding promise or to, in any way deviate from what the collective bargaining agreement provided?
So 2 points. One is the fact that they were benefits officers acting pursuant to a policy that was blessed by mayors and the deputy mayor for health and human services they were clearly acting within the scope of their authority. These weren't rogue employees talking about something that they weren't responsible for. Obviously, any city policy has to be communicated by people on the ground.
When you say scope of their authority, what exactly do you mean? Are these people authorized to make good on any promise with respect to what the benefits are going to be?
No, Your Honor. They're only authorized to make good on, to be held accountable to those promises that they are authorized to make and that are within their job description. I would note, not a single affidavit from anyone saying that those benefits officers were making promises outside of their authorization.
So if the promises were different from what the SPDs provided, is it your view that the SPDs would control, or whatever oral representations were made would control?
I would say in that situation, it might be unreasonable to rely on a promise that differs from, that conflicts with other sources of information. If it conflicted with a statute, if it conflicted with a collective
But
bargaining
here, the
agreement.
SPDs I'm asking about, if the SPDs provided something different from whatever the affiants attest to in terms of oral representations, which in your view would control?
So if there was a direct conflict, I think that there are conversations that could be had, where if it's coming from the Deputy Mayor for Health and Human Services, that would likely control over an SPD. But that's not an issue here because there's no inconsistency. The
What
SPD
about the statements of mayors that went along with these SPDs?
Yes.
How did they, what is the effect of those?
It just reflects the fact that these weren't rogue employees making statements that they didn't know what they were talking about. This was a concerted recruiting and retention
But what
tool.
about with respect to, in 1983, there's Mayor Koch, he speaks of times of rising health care costs, et cetera. Doesn't that contradict that the SPDs were making a promise for life?
Those statements, first of all, I think they were only made in one or two SPDs over the course of 59 years, mentioned just generically that rising costs could potentially impact the city's finances and employee benefits in unspecified ways. They didn't directly contradict the clear promise of Medicare plus supplemental insurance
What
for
about the
59
fact
years.
that the SPDs changed from year to year? Does that impact your claim that?
So I think it's helpful to understand what the SPDs are. They are basically a bifurcated document. There's the first half that provides information about the city's health insurance program in general. It provides information about the policies underlying that program. The second half says, here are the list of plans offered through the health benefits program. Now, those plans, over 59 years, there was some change in the number of plans or the specific insurance carriers, very little for Medicare-eligible retirees. But
So
the first,
doesn't what you've just now stated go more to their informational in nature as opposed to a promise?
So SPDs have been found in various cases that we cite as being able to make a binding promise. And at the very least, it is just one of multiple sources. There are HR documents. There are these in-person communications.
There was never a promise that Medigap would continue indefinitely in any of those SPDs, right?
You mean the program of Medigap or
Yeah.
just the offer of Medigap?
Well, how do you distinguish that?
So I don't know that there needs to be an assurance that the concept of a Medigap plan or Medicare would exist indefinitely. But it was a promise. It was a statement for 59 years, just continuously. in all
A
these
promise to
SPDs.
do what?
Yes.
What was
When
the
you
nature?
retire and become Medicare eligible, you'll be entitled to Medicare plus supplemental insurance.
That's in the SPD? That promise is in the SPD?
That promise is in the SPD, it's in HR documents, and it's reiterated in repeatedly throughout these retirees' employment.
Could you, through bargaining, have put that promise into a collective bargaining agreement?
So I'm glad you asked about collective bargaining, because I think that's one of the most powerful pieces of evidence in our favor. Clearly.
Can you just try to answer
Oh,
that
sure.
first and then say whatever you want to say?
Yes, it is certainly possible to address retiree health care benefits. It is telling that across...
You could have put that into a collective bargaining agreement.
I don't think there's any prohibition against talking about retiree health care benefits in these TBAs, but the critical point is that across 102 municipal unions for 59 years, not a single one of them addressed health care for Medicare-eligible retirees. They addressed the most trivial things you could imagine, the type of stationery that would be used in correspondence. But all of them, for 59 years, didn't say a peep about Medicare-eligible retiree health care. The reason has to be, it's clear, that because it was so fundamental to working for the city that you would get Medicare plus supplemental insurance, not a single one of these 102 unions thought it necessary to address that fact in a single collective bargaining agreement.
Well, could that be because there was an administrative code provision that guaranteed something?
Well, that is one of our causes of action, that Administrative Code Section 12126.
Well, it guarantees something. There's no dispute that it guarantees something, right? It's just a dispute about what it guarantees.
That's true, but it also guarantees it for employees. All of the employee health care benefits were addressed in these CBAs. So they felt it necessary to talk about health care for employees. Didn't say anything about Medicare-eligible retirees, when clearly health care is incredibly important to these elderly and disabled retirees. So I think the collective bargaining agreements, again, if they said something that contradicted the promise, that would be a problem for us. They didn't say anything, and so I know that the court mentioned, or my friend mentioned, when you have a contract on point, how can you have a promissory estoppel claim? The law is that when that contract doesn't speak to that specific issue, there is no bar to a promissory estoppel claim. Here, promissory estoppel is about fundamental fairness. For 59 years, the city, from the highest levels of government all the way down to benefits officers, assured everyone.
Okay, so just to be clear, you say language in the SPDs. You say it's these oral communications from high-level and perhaps mid-level individuals. You say it's certain HR documents. Is there anything else in the record? From your standpoint, that establishes this promise over time?
I can't think of what else there could be. It's conversations in person.
And then your point about the CBA right now, I understand that.
Correct. And the fact that I do think it's telling, although it's not affirmative evidence, the fact that not a single current or former city official was willing to say under penalty of perjury that A, this promise wasn't made, B, I never heard of this promise, or C, if it was made, that's outside the scope of their authority. I think that's telling. And the fact that there was complete silence just underscores the effect of the hundreds of affidavits, including from former Deputy Mayor Lillian Barrios Paoli. And
what about his point that really all she is relying on is the SPD, so the whole case turns on the SPDs?
That is just incorrect. I would just point the court to the actual affidavit itself. It is not saying that this is all reliant on the SPDs. The city, it just so happens that their only argument is with respect to the SPDs. The SPDs is just one type of written document, but there are oral promises made to all the retirees. That is the unrebutted evidence, and that was found by the courts
What's the
below.
language from your perspective again? Because as you say, your friend on the other side has already made his argument about how the SPDs don't have any language that would even suggest a promise. What's the language you would say that, if you're not going to look at anything else, this is the language in the SPDs that assures the promise?
Sure. So for over 50 years, the SPDs and other HR documents said the following. When you or one of your dependents becomes eligible for Medicare at age 65 and thereafter, your first level of health benefits is provided by Medicare. The health benefits program provides a second level of benefits intended to fill certain gaps in Medicare coverage. That is Medicare and Medicare supplemental insurance. Everyone who was working for the city would clearly understand that to mean that when you or one of your dependents becomes eligible.
If that is a promise, as you say, then what would be a description, as in SPD? It's hard for me to imagine what other less committal language you could use that would constitute a description of the coverage that exists, which is, I guess, what the SPD is trying to do, right?
The fact that the first part of that representation speaks to what happens when you reach 65 and thereafter.
Yes. Well, no, it says when you reach 65, you're going to be covered by Social Security, which is your first level of health benefit, and it's provided by Medicare. And then it says the program provides a second level of benefits intended to fill certain gaps in Medicare coverage. That, to me, sounds very descriptive. There's nothing about you will have this or this will last that long. I mean, I think that's, especially when you're talking about promissory estoppel, which is equitable in nature and really has to be quite clear and unambiguous, there's none of those words that we traditionally associate with promissory estoppel.
Your Honor, even if that's true, and I obviously disagree with that, that doesn't at all address the fact that for 59 years, the city told these retirees before they worked for the city, throughout their employment, and throughout their retirement, that when they became Medicare eligible and retired, they would receive Medicare plus supplemental insurance. So
It doesn't quite use those words, right? You just read them. It doesn't quite say that.
sorry, I was talking about the actual oral promises, the
Representation.
in-person promises.
How can those be relevant for anyone other than the individual that they were made to? I mean, an oral representation is by its nature you and I talking, right? So what is its relevance beyond the specific retirees that are attesting in the affidavits?
Because the affidavits of Ms. Barrios Paoli, by the president of the New York City Organization of Public Service Retirees, and by the retirees themselves, talk not of individual conversations, but at information sessions, at recruiting sessions.
Okay, but even beyond that, why wouldn't you have to establish who it was that actually attended particular recruiting sessions or benefits conversations, and whether or not the representations at each and every one of them were the same? It seems to me that that's different than the SPDs or perhaps statements on a website, which are more broadly distributed and accessible.
The fact that the affidavits that were unrebutted speak of the same type of promises made at every possible opportunity.
You're asking us to infer that every retiree received an oral representation? That seems like a bit of a leap.
I don't think it's a leap from the affidavit of Lillian Barrios Paoli.
What about,
who talked about
what about detrimental reliance?
detrimental reliance, again.
I don't think there's anyone who ever took a job with the city who didn't care about health care because perhaps they had a spouse who got coverage in this.
But, Your Honor, even if that's possible, although I think it's pretty clear that the retirement benefits you get by working for the city is one of the key reasons why people work for the city. But even if that's true, one of the types of detrimental reliance that clearly applies to everyone is that if they were led to believe that they would get Medicare plus supplemental insurance, they clearly had no opportunity to budget to pay for Medicare supplemental insurance on their own. These retirees live on razor-thin budgets, pensions. They carefully budget their retirement.
But again, that assumes that each and every retiree is using their own benefits and not a spouse's benefits, which can't be the case. I don't know. I'm just trying to understand why there's not an individualized showing that's required either with regard to an oral representation or, as the Chief Judge says, detrimental reliance.
So, Your Honor, at the most, that means that there are some number of retirees who were made the promise and detrimentally relied on the promise. The way to, obviously, it's impractical to get
But counsel, I'm sorry, if there are some, if you're willing to concede that there are at least some employees who were made promises and who detrimentally relied on it, I could understand that justifying the relief that you're seeking or substantiating a promissory estoppel claim as to those individuals. But again, when you're dealing with an equitable cause of action like this, you need to make that sort of baseline showing for every person that you're giving relief to, don't you? Or can we just give it out like on a class basis?
So this was an essential recruiting and retention tool. This wasn't made in one-off conversations by rogue employees here or there. It was made
Do you think every employee received that speech?
during the course of their career. They have to have worked at least a decade or 15 years. The fact that these conversations were...
I was a city employee for a few years. I might have been given that speech, but I don't remember that I was given that
Well, Your
speech.
Honor, we brought this as an Article 78, hybrid Article 78 proceeding and a putative class action. We were prepared to move forward through the class action. My friend
Was there
here,
a class certified?
there wasn't. My friend here wasn't trial counsel. I was. And I think my friend misrepresented what happened at the trial court level. After we submitted our petition and memorandum of law in support of the petition, the city answered and submitted their memorandum of law. Then we had a hearing on the petition. The court asked us how we wanted to proceed, given the fact this wasn't just an Article 78 proceeding, it was also a putative class action. And trial counsel, including myself, said, "We will get back to you, Your Honor." A month passed with constant conversations with the city. And in that month, we were litigating a parallel retiree health care case, also involving promissory estoppel, where the city took the position that wherever government operations are involved, there's no need for it's unnecessary and inappropriate to have a class action. And the city said that it would provide relief to all, it would provide relief uniformly to all retirees if the judge issued a decision.
In this
Is
case-
that a version of saying that they said, if we're found to have made the promise, we'll honor the promise?
Yes, and that was in the other case, but I'm just saying that happened in that month period when we were going back and forth with trial counsel. And in response to the court's direct question, how do you want to proceed on this putative class action? We talked, the city, of course, doesn't want to take the diametrically opposed position to the one it had just taken on July 14th. And so on August 8th, the parties submitted a stipulation that said, no, we don't need to submit anything further. There's no need for other proceedings or submissions.
Can I just be clear on this other point that was being made about reliance? I thought your position was that every person who would be in this class is someone who wants this health coverage care now? It's not that they have any other health care coverage that they would depend on?
That's correct, Your Honor.
Okay, all right,
Yeah.
thank you.
Counsel, just maybe this ties up a few of the questions that have been asked, but the appellate division described this as a singular case, right? And they went through, I think, 3 factors. Promissory estoppel in this context raises a number of issues, and I think that's what these questions have been getting at. If we were to rule in your favor, how would this case and that ruling affect future cases of people alleging promissory estoppel in various contexts, and how singular would this model be?
I think, as I said in our brief, this is a singular case in a number of respects. One is the record. You have hundreds of unrebutted affidavits from retirees and city officials confirming the promise and detrimental reliance. Those are factual findings that cannot be challenged here in this court. 2, you're talking about not just any promise. This isn't sort of a commercial promise of the type that the city, the cases that the city relies on. This is about health insurance for people in their 70s, 80s, and 90s who are elderly and disabled. They relied on that promise that was made for over 50 years, orally and in writing. And there's just a number of factors. It was made to recruit and retain these individuals. And so if a city out there wants to avoid the repercussions of a decision by this court affirming, it can easily do that by simply not promising everyone for 50 years unequivocally.
I mean, I guess some of our concern is that this promise that you're suggesting exists based on language that isn't as strong as you're making it out to be. And the question is, shouldn't government be allowed to offer information to retirees and allow people to come in and have information sessions and learn about their health care benefits without being chilled to think that whatever I say now and whatever happens in this office will now bind the city indefinitely on language that isn't as precise as you're sort of intimating that it is?
Absolutely, Your Honor, but what the government can't do is adopt an essential recruiting and retention policy that misleads people to, people who are high quality, who otherwise wouldn't come work for the city, but to lure them in with the promise and then wait until they're elderly and disabled, past the point where they can go back to work or afford this insurance, and then do what Mayor Adams said when he was running for office, engage in a bait and switch. That a city cannot do. But it can definitely explain, this is their benefits now. This is not, I can't say that this will be the benefits that'll be in place when you're 65 and thereafter. But that is exactly the promise made by every single.
There's no document that says this health coverage is contingent on the budget. This health coverage is not guaranteed upon retirement. Or this health coverage may change during any period of time.
No, Your Honor, there isn't a single document. The city poured through the SPDs for 50-something years, the other HR documents that we presented, couldn't find a single reservation of rights in those documents. And there's no evidence in the record to suggest that in the promises that were made in person that the city officials ever communicated, but obviously this comes with the caveat that it depends on our financial situation.
Counsel, can I just check with you very quick over here about the CBA? We don't have any CBAs in this record, do we?
So not in this record. In Campion, the case that was before this court several months ago, contains the CBAs, but it's undisputed by the parties that the CBAs
Don't mention retiree benefits.
correct.
at all.
And if it did, that would be, I think, fatal to our argument. If the CBA said, we negotiated it, here's what you're getting as a Medicare-eligible retirees, but obviously that benefit is critical to working for the city. Again, like I said before, the fact that 102 unions over the course of 50 years didn't once mention this is what you're going to get when you're elderly and disabled, I think underscores the fact that it was just widely understood by everyone that what you get is Medicare plus supplemental insurance. So I think the CBAs, again, is one of the most powerful pieces of evidence in our favor. But if the CBAs, if there was a single CBA that said, when you're Medicare eligible, you're going to get, you could get this, you could get that, the city obviously would have submitted that, and that would have been devastating to our case. If the city had submitted evidence of, a statement by anyone saying, by the way, I'm just warning you, as we always do, that we can't guarantee that this insurance that we've represented to you you're going to get will necessarily be the insurance you get when you're elderly or disabled.
But in a promissory estoppel case where we're looking for some sort of affirmative commitment from the person who is to be bound, wouldn't the better evidence be that there was some promise made to provide the benefits in a CBA as opposed to the absence of any mention of the benefits?
Absolutely, Your Honor. And those were covered in my discussions of the affidavits.
The other
That was-
things.
Yes, exactly.
Okay.
Thank you.
Thank you, Your Honors.
Judge Garcia, I want to respond to one of your questions. What would the implications be? They would be broad and profound. And I think the two things to remember. There are, the cake is baked around this state, not just the city of New York, governments around this state on SPDs, many, many years going back, and CBAs, many, many years going back. If you say now that this equivocal language in an SPD can constitute override the product of the CBA and result in a lifetime promise, the ramifications for already existing CBAs and SPDs will be
But their position
broad.
is it's not just the SPDs.
Well, I want to address that, I think,
Right, you're
because
saying there's
I
something
think-
unique, so
I
yes.
believe Mr. Gardner said all the retirees got oral promises. We point out, I would direct the court to our reply brief, a series of footnotes in our reply brief. I think they're on pages 4 and 5. We point out, just of the affidavits in this case, not even to mention the other 249,700 retirees who never put in an affidavit, just in the affidavits in this case, about 130 affidavits don't say anything about ever an oral promise ever having been made to them.
Could I ask you for a second to address the Moratorium Act? Because it seems to me that as to teachers, it is intended to have some effect.
It is, and I think the biggest issue and the simplest way to resolve the Moratorium Act claim, as Your Honor points out, it's just for school district retirees, is, and this goes to my point about the record closing and how there were trade-offs, I think, made by both sides. They didn't carry their burden on moratorium. They didn't introduce any analysis of the plan, the totality of the plan versus totality of senior care on a group-wide basis.
Was it squarely ruled upon below?
I know that Justice Frank said he was not ruling upon, it hasn't been ruled upon. It was rejected by the appellate division, was not ruled upon by Justice Frank. I honestly don't think there's any way you could grant judgment for them on this stage.
Why not remit and let a record get developed?
Because I think it's pretty straightforward. They didn't carry their burden. I think for guidance, you can look to Colby, and that case is about a collective bargaining agreement, but it talks about how you might interpret a provision that guarantees a form of equivalent coverage, equivalent level of coverage, as this statute does. It cites approvingly two cases, the Poole case from the Connecticut Supreme Court and the Deal case from the Seventh Circuit, that lay that out. And I just say, if you look at that framework, they didn't make any effort to carry their burden, so that claim should be dismissed.
Is there any language in any of the documents that retiree health care benefits are dependent on the budget?
A number of them say the benefit levels are dependent on the budget, dependent on collective bargaining. These are in SPD after SPD. We cited this in our brief. I just want to button up something on the oral promises. As I said, 130 affidavits don't mention it, not to say anything of the other 249,000. Many of the others, and these are in our footnotes too, just say that orally they reiterated what was said in the SPD, as Your Honor says. You want benefits people to be able to to communicate about what SPDs say, and they shouldn't do so at the peril of not, particularly when we have shown, I think, that the SPD didn't make a promise, at the peril of those communications being understood now as some kind of lifetime promise that binds the city. Mr. Gardner referred to a policy, quote, policy. I don't think you will see in Barry Paoli's affidavit that she said there was a policy of making this promise orally to people. She doesn't use that word. She also doesn't say she had any duties or control or input over benefits policy. And the only last thing I would say is just a note about in the SPDs, they started out as the centerpiece of this case. They now are a footnote. They've shifted, they understood, I think, early in this case that if they only had one path to possibly win, and it was the SPDs, I think as this case has unfolded, they have seen more and more that they will not win under that path. They've tried to pivot out of it. That case, it cannot work in that form, and they've done the same thing on the CBA. In Campion, they said the CBA provided them the benefit they were looking for. Now they say it was so fundamental, no CBA ever had to whisper a word about it. They do not have a sustainable case, and the court should dismiss it.
Thank you.